Today, I do not merely want to discuss another GST judgment. I want to discuss a judgment that may fundamentally influence the future of input tax credit litigation under GST. The decision is Maruti Enterprises versus Union of India, delivered by Gujarat High Court. Now, many of us initially looked at this judgment as just another ruling upholding Section 16(2)(c). But if we stop there, we miss the real significance of the decision. The real importance lies not in the conclusion alone, but in the interpretative path adopted by the Gujarat High Court. Because what the court has really done is this: it has consciously departed from the entire VAT era philosophy that protected bona fide purchasers. And unless we understand that shift in judicial thinking, we cannot properly advise clients in future GST disputes. The entire controversy before the court was simple. Can a purchasing dealer lose ITC merely because the supplier failed to deposit tax with the government? For years, taxpayers relied upon the famous Delhi High Court judgment in On-Quest Mercantising India Private Limited and the connected decision in Arise India Limited. Those judgments essentially said a bona fide purchaser cannot be asked to do the impossible. If I purchased goods genuinely, received the goods, paid consideration, paid GST, verified registration, and obtained proper invoices, how can I be punished because the supplier later defaulted? That line of thinking was based on fairness. It was based on impossibility of compliance. It was based on protection of innocent purchasers. In fact, courts repeatedly used the maxim, the law does not compel a man to do the impossible. And for many years, this became the emotional and legal backbone of ITC litigation. Now comes the Gujarat High Court. What is fascinating is not that the court disagreed. Courts disagree all the time. But here, the court methodically dismantles the very foundation on which earlier judgments stood. The court says all these earlier judgments came from a completely different tax architecture. This is the first major interpretative shift. The court repeatedly emphasizes that GST is not VAT. Under VAT, credit largely remained within the state. Under GST, credit crosses state boundaries through IGST settlement mechanism. And according to the court, this changes everything. The court says if credit is allowed without actual tax reaching the government, the originating state may have to transfer funds to another state despite never receiving the tax in the first place. Now, notice the interpretative approach. Earlier courts focused on what can the purchaser realistically verify, but this court shifts the focus to what happens to the GST fiscal chain if tax is not actually deposited. That is a massive jurisprudential shift. The court moves from a taxpayer-centric interpretation to a system-centric interpretation. That is the heart of this judgment. The second major interpretative change relates to the nature of ITC itself. Earlier decisions treated ITC almost as a substantive entitlement once conditions relating to genuineness were satisfied. But the Gujarat High Court repeatedly calls ITC a statutory concession. Why is this important? Because Once the court classifies ITC as a concession rather than a vested right, the entire constitutional analysis changes. If it is a vested right, courts apply stricter scrutiny. If it is a concession, the legislature gets much wider discretion to impose conditions. That single interpretative move substantially weakens Article 14 challenges. Then comes another nuanced aspect. The petitioners argued something very clever. They said Section 16.2 contains multiple clauses A, AA, B, BA, C, and D. Clause A, AA, B, and BA already verify genuineness. Invoice, reflection in GSTR 2A to B, receipt of goods, absence of restriction. So once genuineness is established, why should clause C punish a bona fide purchaser for supplier default? Now this argument is extremely sophisticated because it attempts to separate genuineness from supplier compliance. But the court rejects this compartmentalization entirely. The court says you cannot stop at clause B. All conditions from clause A to clause D must operate conjointly. Again, notice the interpretative philosophy. Earlier, courts separated purchaser conduct from supplier conduct. This court integrates both into a single compliance chain. In other words, the court is saying GST is not a bilateral tax system. It is a chain-based compliance system, and unless the chain is intact, credit cannot survive. Now let's come to perhaps the most significant portion of the judgment, the court's treatment of earlier precedents. This is where tax consultants must pay close attention. The Gujarat High Court does not openly attack on Quest Merchantising India Private Limited. Instead, it distinguishes it structurally. That's a very sophisticated judicial technique. The court says the Delhi High Court decision did not consider Section 41, subsection 2, Rule 37A, Section 53, and Section 155 of the CGST Act. This becomes the foundation for differentiation. Now understand why this matters. Under VAT, there was no statutory re-availment framework comparable to Section 41(2) and Rule 37A. But under GST, the court says credit reversal is not permanent. Once supplier pays tax, recipient can re-avail ITC. Therefore, according to the court, the hardship is temporary, not confiscatory. This is extremely important because the court uses this mechanism to defeat Article 14 arguments, Article 19 arguments, Article 300A arguments, and even the double taxation argument. Earlier courts said, you are punishing an innocent purchaser. This court says, no, we are only postponing the benefit until tax reaches the treasury. That is a completely different interpretative lens. Then comes another remarkable aspect. The court invokes Section 155, burden of proof. This is strategically significant because earlier jurisprudence largely focused on what the department must prove. This judgment shifts attention to what the purchaser must prove. And the court says eligibility itself includes proof that tax was actually paid to government. This enlarges the meaning of eligibility. Again, a subtle but powerful interpretative expansion. Now let's discuss perhaps the most controversial part of the judgment. The court practically says purchasers should protect themselves contractually. The court suggests indemnity clauses, due diligence mechanisms, and contractual safeguards. Now, from a litigation perspective, this observation is extremely significant because future departments may now argue you are expected to conduct commercial due diligence. This could gradually evolve into a judicially recognized compliance expectation. And this is where practical GST advisory may fundamentally change after this judgment. Vendor onboarding, contract clauses, compliance tracking, payment hold mechanisms, all these may become critical evidence in future litigation. Now let's look at the doctrine of reading down. The petitioners wanted the court to read down section 16(2)(c) so that it applies only in fraudulent or collusive cases. Earlier, courts were willing to do this, but the Gujarat High Court adopts a far stricter approach. The court says reading down applies only where literal interpretation creates constitutional infirmity. And since the provision is clear and unambiguous, the court refuses to dilute it. This again reflects judicial restraint in physical statutes. In tax jurisprudence, courts are increasingly reluctant to rewrite legislation merely because hardships exist. And the court expressly says harshness is not a ground to read down a valid fiscal provision. Friends, what is the broader takeaway from this judgment? The Gujarat High Court has effectively announced that GST jurisprudence cannot be mechanically borrowed from VAT jurisprudence. That is the central message. Earlier courts focused heavily on fairness to the purchaser. This court focuses on preservation of the GST architecture. Earlier courts asked, can the purchaser verify supplier compliance? This court asks, can the GST system survive if credit flows without tax collection? Earlier courts emphasized impossibility. This court emphasizes fiscal integrity. Earlier courts individualized the transaction. This court systemizes the transaction. That is the real evolution we are witnessing. Now, whether one agrees with the judgment or not is a different matter. But as professionals, we must recognize that this judgment substantially strengthens the department's future defense of Section 16(2)(c). And more importantly, it signals the direction in which constitutional GST interpretation may now move away from equitable considerations towards structural preservation of the GST framework. Therefore, for tax consultants, the lesson is not merely litigation strategy. The lesson is preventive strategy. Tomorrow's successful GST advisors may not merely be someone who argues well before courts. It may be someone who builds compliance architecture before disputes even arise. Thank you.